surrender the lease to the lessor by mutual agreement in between them, whereas clause F provides the lease can be determined by the implied surrender. Point number 29, which is the finding. Pursuant to the agreement to sell dated so and so shows that though the agreement contains 9 conditions, but none of the conditions provide such less in a specific terms as to what would be the fate of tenancy. In other words, none of the conditions set out in the agreement dated so and so can be construed for holding that the parties intended to surrender the tenancy. A fortiori, the parties did not intended to surrender the tenancy rights despite entering into the agreement to sell all the tenancy premises. In other words, if the parties really intended to surrender the tenancy rights as contemplated in clause E or F of section 111 of the Transfer of Property Act, while entering into the agreement to sell the suit house, it would have necessary provision to that effect by providing specific clause in the agreement. It was, however, not done. On the other hand, we find that the conditions set out in the agreement do not make out a case of express surrender in clause E or implied surrender in clause F under section 111 of the Transfer of Property Act. This is for this reason laid down and by this court in Kanti Mati has no application in facts and circumstances, therefore is distinguishable among facts. Point number paragraph 32. As observed supra, such is not a case because we do not find. Lord, but this is the same line Lordship has proceeded in 1 second appeal. This is the same principle Lord Supreme Court has also proceeded ahead. We have to see the contents of the agreement. Lord, as Lordship has rightly pointed out, the last portion of the agreement, Lord, the tenancy right still exists, which says, Lord, that if the amount is not paid, the tenancy will continue. There is no express surrender, Lord. Likewise, Lord, in the 2000 judgment, Lord, is there. The last judgment is there, 2025.
Yeah, 25.
Somnath. Unreported judgment.
Yes, Somnath.
Lord, here also, Lord, the agreement was there. Subsequently, agreement to sell was entered into between the parties. And juror relationship, they claim that there is no relationship, juror relationship, Lord. Lord, paragraph number 30, Lord, is pending. Lord's permit, I can read the facts.
Yes, just. Findings at paramount.
13 and 14.
Yes.
As per section 54 of Transfer of Property Act, a contract for sale of Indian property is a contract that the sale of such property shall take place on the terms settled between the parties. It does not at all create any interest or charge in such property. Thus, even if the suit for specific performance is decreed without a degree for specific performance, transfer or possession of the suit property, the same can be enforced only when the court directs the judgment dated to convey a suit property to a degree holder. It is only after registration that a transfer of title would take place from one to another. In the instant case, admittedly, the degree for performing specific performance was conditionally decreed, and decree holder had failed to fulfill the condition. Therefore, the decree would not fortify into a conveyance. In such circumstances, there was no transfer of property from appellant to the respondent. Thus, there is no termination of landlord-tenant relationship between the parties by virtue of section 111D of the Transfer of Property Act. In consequence, there is no good reason for the High Court to set aside the complaint pending in both. Lord's permit, I can read the facts also. But here, my lord, the case was that, my lord, the suit for specific amount was initially filed by the defendant, which was a decree, and there was direction to deposit certain amount. Certain amount was not deposited, therefore the decree was vitiated. And thereafter the eviction suit was filed. And there they took a stand that my initially suit has been decreed, however I had not made payment. The court thereafter proceeded ahead and held that since the decree was passed and you did not make the payment, therefore you cannot take that claim.
That's all. Anything else you want to say?
Not one more thing. That 1999 judgment will not teach again judgment. That is of the same principle. Not, I put a small tick on the relevant portion below the second page, para number 4.
Just a moment.
Lordship, I can read the entire thing.
Yes.
Only said that suit. Sorry.
Just a moment. What do you want to say by this judgment?
By this judgment that Lord is shall I read or shall I?
No, you
Lord,
just
yes. Lord, that suit of specific offence is pending unless and until that is decided. Their relationship with landlord tenant still exists, and they are I am landlord and they are tenant, and therefore there is a right to.
the terms and conditions of the agreement were neither placed nor subject matter of
Yes.
consideration.
Lord, they only cannot hear.
There was just an agreement of sale.
Yes.
So therefore, terms and conditions did not fall for consideration
Yes.
in this case.
Yes.
Right?
Yes.
That's correct.
Yes, that's correct.
But in the judgments which are cited by
Yes.
the Honorable Supreme Court, etc.,
Yes.
terms and conditions of the agreement have been taken into consideration
Yes.
as to how the parties they were positioning themselves.
Yes.
But that terms and conditions
Yes,
are
that
not
is not there.
under consideration. It is just on a simple
Yes.
principle that if there is an agreement of sale, there is no transfer, and merely because
Yes,
suit for
yes,
specific
yes.
performance of
Yes.
contract is there, that will not confer ownership
Yes.
on the tenant.
Well,
So on this score, this is distinct.
yes. That's
Similar is the situation with all the judgments.
other
Terms and
previous
conditions
judgments.
of these High Court judgments.
Yes, yes.
Terms and conditions
Ah.
of the agreement is
That
not the
2018
subject matter of
judgment is
consideration.
also not, although he had considered 2001 judgment when it has been considered, but terms and conditions have not been considered.
Are not the subject
Yes,
matter of
not
consideration in all these
Yes.
judgments.
Therefore, Lord, when Lordship has fallen from the Lordship, I stopped not to place that judgment. Although this judgment was considered, but not happily
Yes.
on the point of
We will not say not happily. There
not the,
was no such argument.
yes, yes.
There was no such argument
Yes.
that because of this clause the parties agreed that
was there,
the
Lord, because the judgment was placed.
I do not know. I will assume whatever is there on the face of the judgment. I will assume that
Yes,
only.
that's-
The judgment might have been placed. That is all.
That's
The learned counsel for the respondents थोड़ा सा लिखाए थे इनका written submission खाली लिखाया गया है ना. The learned counsel for the respondents by referring to the judgment passed by the learned trial court.
मेरा सब इनिशियली लिखाया गया था.
आपका खाली written submission में क्या था बस उतना ही
बस
लिखा है.
जी.
उसके बाद आप सीधे impugned judgment में.
मेरा,
Right?
वो नहीं हुआ था
वो वहाँ से नहीं.
नहीं.
So I'm just referring.
Yes, just a few one.
The learned counsel for the respondents by referring to the impugned judgment passed by the learned trial court has in particular referred to the trial court में है कि appellate court में?
Appellate court.
हाँ. By referring to the appellate court's judgment has in particular referred to the evidence of figure 1, 2 and 3. And has submitted that PW1 has clearly stated that as per the tenancy, that the tenancy was at the rate of rupees 15,000 per month, and it was wrong to say that the tenancy was rupees 3,500 per month, and it was also wrong to say that husband of the plaintiff had entered into agreement for sale with respect to the suit property and have received rupees 1 lakh through check and rupees 4,000 in cash. This witness claimed that the agreement of sale with the husband of the plaintiff was forged. During cross-examination, she has stated that the power of attorney holder had told her that the defendant had paid rent till 2003 through check of rupees 1 lakh. Power of attorney has not been examined.
PW1.
PW1 is the
PW.
Name is PW2, PW2. Or
PW2 has been examined, who is the power of attorney. Who stated that the rent was at the rate of rupees. Who stated that it was wrong to say that the rent was at the rate of rupees 3,500, and had stated that the defendant had defaulted in payment of rent since January 2004. During his cross-examination, the suggestion that after MOU the defendant had paid the witness rupees 1 lakh by check out of consideration amount of rupees 35 lakhs, the witness stated that the rent from June 2003 to December 2003, that the check of rupees 1 lakh was paid from June 2003 to December 2003, and the defendant had assured to give rupees 5,000, which he did not pay. PW3, by referring to the evidence of PW3, he has stated that this witness has also claimed that the agreement of sale was forged. The learned counsel submits that the specific case from evidence of the plaintiff witness was that the agreement of sale as well as the memorandum of agreement was forged, and therefore no reliance can be placed upon these documents. This is without prejudice to the submission of the learned counsel for the respondent that the agreement of sale was compulsorily registrable and was not admissible in evidence. And he has also stated that the plaintiff had, that the defendant had specifically referred to the agreement of sale to seek protection under section 53A of the Transfer of Property Act by stating that they came in possession of the property as part performance of the agreement. And since the agreement of sale was unregistered and was post 2001, no such reliance could be placed by the defendant. He submits that the plea based on section 53A of the Transfer of Property Act has been rightly rejected by the learned court. The learned counsel has submitted that The judgment reported in bracket 2000 bracket close 9 SCC 339 has been rightly said to be distinguished. Distinguished क्या है क्या? ये तो खाली submission. इसको last sentence. The Learned Counsel has referred to paragraph 17 of the appellate court's judgment and has submitted that the Learned Court has rightly refused to rely upon the unregistered agreement of sale and has rightly held that the judgment reported in bracket 2000 bracket close 9 SCC 339 was not applicable in the present case. The Learned Counsel then relied upon the judgments passed by High Court by this court reported in bracket 1999 volume 2 PLGR 189 APA. Then next is 2003 within bracket 1 JLJR 591. Then you have this 2009 within bracket 3 JLJR 19. And has submitted that merely because it has been clearly held that merely because there is an agreement of sale, the same will not terminate the relationship of landlord and tenant between the parties, and pendency of a suit seeking specific performance of contract has no bearing in the matter. However, during the course of arguments and upon perusal of the aforesaid three judgments, it is not in dispute that the terms and conditions of the agreement of sale in each of the case was not the subject matter of consideration. Though another judgment which has been relied upon by the respondent is reported in 2018 within bracket 4 bracket close JCR 273 within bracket JHR Ashwini Kumar Pal, alias Koda and others to come. The same has also been placed but paragraph 32 of the same judgment reveals that the same was on a different set of facts. Paragraph 32 में है ना, मतलब only one of the party has entered. Undivided portion and right. The Learned Counsel has also relied upon the judgment reported in bracket 2022 bracket 13 SCC 756. In which a petition was filed under Order 12 Rule 6 of CPC on behalf of the defendant which was dismissed by the Learned Trial Court, refusing to pass the decree on admission. However, the revision was allowed by the High Court, and the matter was before the Honorable Supreme Court.
The judgment was not the issue. Judgment is not placed.
Not necessarily.
In 2000, judgment was not relied upon in this case.
The Learned Counsel has pointed out that the judgment passed in the case of Kanthimani Sutra was not relied upon in this judgment. Cite हुआ था क्या?
Cite नहीं हुआ.
Was not cited
Not cited.
in this judgment. इसको रखना जरूरी है? नहीं, मतलब एक पॉइंट पे अगर मान लीजिए मल्टीपल जजमेंट्स हैं तो अगर जरूरी है तो रखेंगे, नहीं तो ठीक है रहने दीजिए, क्योंकि एक पॉइंट पे मल्टीपल जजमेंट्स की जरूरत नहीं होती, एक ही जजमेंट बहुत अच्छा लीव इट, इसको हटा दीजिए। ये वाला 22/13 का 7/6 The Learned Counsel has relied upon the judgment reported in AIR 2025 SC 2933 and has submitted that it has been clearly held that unregistered agreement of sale cannot under any circumstances create or convey any right, title or interest in favor of a party under section 54 of the Transfer of Property Act. It is referred to paragraph 9 of the Equity Judgment. In particular, which is quoted has been referred to paragraph 18 and 19 of the same judgment.
9.2 का 18. 9.2 का judgment कोट किया है. 9.2.
ये तो quoted है.
9.2 में quoted है.
Para 18 and 19 is quoted in 9.2.
Yes, previous page. But page number 2940.
7. Actually, okay. He has referred to paragraph 9.2 of the same judgment to submit that the law is well settled, that the transfer of immune property by way of sale can only be by deed of conveyance, and in absence of deed of conveyance, no right, title or interest in a new property can be transferred. And it has also been held that any contract of sale which is not registered deed of conveyance would fall short of the requirement of section 54 and 55 of the Transfer of Property Act and will not confer any title nor transfer any interest in any property except to the limited right granted under section 53 of the Transfer of Property Act. The Learned Counsel has submitted that unregistered agreement of sale can be used for the purposes of specific performance of contract as well.
Suraj Lamp got it as
Suraj Lamp concept.
2012.
The Learned Counsel has then referred to the judgment passed by the Honorable Supreme Court reported in the case of Suraj Lamp Sutra and has referred to paragraph 19 of the same judgment, which is quoted as under.
18 and 19.
18 and 19. Okay, 18 and 19. On the similar proposition, the Learned Council has then referred to the judgment passed in Civil Appeal number 4484 of 2025, decided on 25th of March 2025, and he has referred to paragraph 13 and 14 of the same judgment, which is quoted as under. The Learned Council has heavily relied upon the judgment passed by the Honorable Supreme Court reported in backward 2019, backward close 4 SCC 153, H.K. Sharma versus Ramlal. And has submitted that the facts involved in the same case was almost similar as that of the present case. And the Honorable Supreme Court has specifically noted that there was no clause in the agreement discerning the intention of the parties to surrender the tenancy agreement either expressly or impliedly. He has submitted that the judgment of Honorable Supreme Court in the case of H.K. Sharma assumes importance in view of the fact that in the present case also, the terms and conditions of the agreement do not indicate that there would be a termination of tenancy by virtue of the agreement. Rather, the agreement reveals that the agreement that the tenancy did not terminate. यही आपका बोला. The Learned Council submits that since that even if it is assumed that even if the clause of agreement is taken into consideration, then also there is at best deferment in payment of rent in terms of the agreement. But the courts have given concurrent finding on the bona fide requirement, which is a distinct ground for eviction under the BTC Act, and therefore there being no intention of termination of tenancy between the parties, the eviction on account of bona fide necessity will still be sustained. दिखाएं हैं आपको ठीक दिखाएं.
One thing, just to add, that in order to show a bona fide, they could have deposited the amount in the court below, that they are ready and willing to
We are not again after to deposit.
नहीं, that would be a suit of special purpose. How can
इसमें तो जब तक आप कोई पिटीशन नहीं फाइल करेंगे for asking them to deposit rent.
To show that the payment was made, that the agreement shows that 10,000 would be paid, if they did not make the payment, they say, but there is a condition in the agreement.
नहीं वो तो specific. इसमें नहीं.
खाली इस चीज के लिए
if I decline,
if I decline to accept the amount tendered by them, then he should have deposited the amount in the eviction suit.
Not in the eviction suit. In the specific performance. इसका कोई आपका रिस्पॉन्स लिखा था?
हाँ.
अभी
हम
अच्छा बताइए.
छोटा सा हम ज़्यादा टाइम देते हैं. Because time and again rupees 1 lakh is coming, and they have also referred to that particular statement of the witness where the witness says that the rent of the amount of rupees 1 lakh was for the period June 2003 to December 2003. So this, what was his statement in the play? And only one paragraph I am reading, paragraph 5, where he says, I'm trying to indicate that this particular adjustment option, whatever was made, stand was taken, it was an afterthought, absolutely an afterthought, which is clear from statement made in paragraph 5 itself, that this defendant was a habitual defaulter in payment of rent. He paid rent up to December 2003 and thereafter In spite of repeated requests, the defendant neither paid nor did. So I have paid till December 2003, and thereafter I did not pay. That means January 2004 onwards I have never paid. Now, when his first witness was being examined, when we cross-examination, when this amount of 1 lakh was admitted by him, then PW2 in his evidence on oath says that yes, I have received a sum of rupees 1 lakh, which is for the adjustment of the period 2003 to 2007. So now this payment was made in the year 2007.
The learned counsel for the appellant in response has submitted that, has referred to the plaint paragraph 5. इसको quote करेंगे paragraph. By referring to the aforesaid statement in paragraph 5, the learned counsel submits that it was a specific case of the plaintiff that the defendant was a defaulter, habitual defaulter in payment of rent, and he paid the rent only till December 2003, and thereafter, in spite of repeated requests, the defendant neither paid the rent nor he has validly tendered the same. The learned counsel submits that when the plaintiff witness was confronted with the payment of rupees 1 lakh check in the year 2007, which was a part of the consideration amount, they tried to wriggle out of such confrontation by stating that the payment was made in the year 2007 for the period from June 2003 to December 2003. It was never the case that the defendant had defaulted, but 2003, the learned counsel submits that it was a clear case of afterthought.
And
What else?
one judgment of Justice Miratia, which he has referred, but only one major distinguishing factor is there was nothing in the agreement to show that the petitioners were not required to pay rent to Shivapati after the agreement.
Where is it?
This is in paragraph 6. The trial court had held as follows, and that in that finding the Honorable Court mentions this matter. Paragraph 6. The trial court inter alia held as follows.
Yes.
After 4 lines, the case of the petitioner was that the vendor Shivapati alone could not sell the property in absence of his co-sharers, but he could not prove that Shivapati alone was not entitled to sell the suit property. There was nothing in the agreement to show that the petitioners were not required to pay rent to the Shivapati after the agreement.
With respect to the judgment passed by this court, reported in bracket 2009 bracket 3 JLJR, the learned counsel has referred to paragraph 6 of the same judgment to submit that it was specifically noticed by the learned trial court that there was nothing in the agreement of sale to show that the petitioners of the case were not required to pay rent after the agreement. And therefore, on the basis of such agreement, it could not be held that the petitioners of the same case acquired any right, title and interest over the property, and their status and possession changed and they continued in possession as tenant and not as owner on the basis of such agreement. And there existed a relationship of landlord and tenant between the parties.
One more clause is there in not in that, not terminated as well. Now, landlord definition and tenant's definition. Because here is a case where we say that after 30/10/2008, there was no payment was being made, and this was in terms of specific clause in the agreement itself. Now, the definition of the landlord, this is alternative argument. Now, the definition of the landlord in terms of the JDC Act of 2000 itself says that the landlord includes a person who for the time being is receiving or is entitled to receive the rent of a building, whether on his own account or so and so. So here, Your Lordship, the agreement very clearly stipulated that no rent would be paid here in Africa. Here is the definition of the landlord. And the tenant says that the tenant means any person by whom or on whose account rent is payable for a building. Rent is payable for a building. Here, no rent was payable for the building after 2008. And what the clause 6, as Your Lordship pointed out, clause 6 only would come into play when I default, when I decline to perform. So if there is no declination on my part, if I do not decline to perform, that clause does not come into picture. Because the word itself is very clear, the second party declines to purchase it. I have never declined. In fact, I have filed a suit for specific performance, that too in the year 2009. So this clause would never come into picture. This is.
The Learned Council has referred to the definition of landlord and tenant as defined under the BBC Act. And has further submitted that as per the clause in the agreement, the defendant was not supposed to pay rent from October 2007.
2008.
2007.
Okay.
From October 2007. And the clause 6 of the agreement would trigger only when the defendant refused to perform in terms of the agreement. He submits that the defendant never refused to perform, and before the expiry of the period of agreement, a suit for specific performance of contract was already filed. As the husband of the plaintiff who entered into the agreement had expired, and the plaintiff refused to perform in terms of he refused to convey the property in terms of the agreement.
This is. And last my submission on personal necessity नहीं वो लोग बोल रहे हैं मेरा consent record नहीं हो, but because it was our endeavor before the lower appellate court, we filed petition that please produce her or at least bring her signature. ऐसा कोई ये नहीं, everything is being done only by parvikar and persons who are not.
Could be the examiner.
सब कुछ लाए हैं हम पे.
Could be the examiner.
वो एग्जामिन हुई ट्रायल कोर्ट ये भी, लेकिन उसके बाद कभी ये
उसके बाद क्या करेंगे?
उसके बाद उसका ये all these steps either have to be taken by the ठीक है हम
इसका क्या ही relevance है?
because he is trying to just bring out that fact that she is 91 years old all those facts. Here is absolutely a question of law.
Law does not give special liberty to senior citizen. The only liberty is that their case is to be expeditiously heard. कोई special status थोड़ी है.
बस वो नहीं है.
Law में कोई eviction suit में ऐसे law में कोई special status.
And that is the only thing again.
Male female का भी कोई special status नहीं.
Just one thing, Your Lordship, correct me, Lord, there is a section 116 of the Evidence Act would be considered.
भाई ऐसा नहीं करते ना, इतना आपको सुन लिया, आपको इत्मीनान से सुन लिया, अब आप सारा डिक्टेशन हो गया तो एक नया सेक्शन लेके शुरू.
बस खाली स्टॉपल का पॉइंट पर था मेरा.
कुछ नहीं है. स्टॉप.
Deeply obliged, Your Lordship, your patience.
मेरा होमवर्क आपको समझ आ रहा है, ये सारे लेयर्स खोल के हम अपना होमवर्क बढ़ा देते हैं, बट आई थिंक ये जजमेंट सही से होना चाहिए, दैट इज माय कंसर्न. These litigations are very layered. इसी वजह से ना हम बहुत फैक्ट बेस्ड जजमेंट करते हैं. फैक्ट्स एक वन वर्ड of difference makes the can change the entire judgment. Concluded. या तो हम डेट देंगे जजमेंट के लिए या फिर सीधी करेंगे, दैट आई विल डिसाइड. अगर अभी उत्तर में लिखा दिए तो आपको डेट दे देंगे जजमेंट का, नहीं तो फिर सीधी. ये सर आपका क्या मैटर है? इतना स्लो कोर्ट में आप लोग कैसे समझेंगे कि कैसे इतना नहीं हो सकता है ना? सीधे ना आप रिस्पॉन्डेंट हैं, कौन है इसमें रिस्पॉन्डेंट? हाँ कहाँ है? कहाँ है? आपका क्या ग्रीवेंस है इसमें?
Lord, ये stay my lord had granted Lord 10-15 days back. Lord.
Okay.
Now that up till today, Lord. And
नोटिस
it is
वगैरह
time
सब हो
for
गया है?
hearing, Lord.
नोटिस वगैरह सब हुआ है? क्या हुआ है?
हाँ? आ गए Lord.
ये सब आइए सब पेंडिंग है अभी. आइए सब पेंडिंग है इसमें. कौन कौन सा आइए पेंडिंग है? आप फ्रेश स्टेप्स लीजिए भाई. रिस्पोंडेंट नंबर 9 का एट इज प्रेजेंट इन करेक्टेड केस. ठीक है?
Now for notice, Lord.
9 पर एट इज प्रेजेंट. आप लोग तो ऑफिस नोट भी नहीं देखते हैं. नहीं देखे हैं ना? सुबह से बैठे हुए हैं कि स्टे एक्सटेंड कर दीजिए. ऑफिस नोट भी नहीं देखे हैं. हाँ, हियरिंग के लिए फिक्स्ड है. बिना सब्स्टिट्यूशन के हियरिंग हो जाएगा या बिना सर्विस के हियरिंग हो जाएगा? पिछली बार नोटिस हुआ था तो आप लोग कौन देखेगा इसको? Who will see this?
There are some plots, your lordship, that the execution already done.
देखिए, essay number 123 of 2006. Substitution अभी हुआ नहीं है इसमें. As per the office note, notice upon respondent number 9 has not been served, and the same has returned unserved. Counsel for the appellant prays for time to take fresh steps for service of notice upon respondent number 9. कितना टाइम चाहिए आपको? At his present and current address कितना टाइम चाहिए? Or to file an appropriate petition seeking substituted service of notice. दोनों में से एक काम कर लीजिए. By Friday? अभी इस फ्राइडे को कर देंगे. एड्रेस आपका गलत बता रहा है. अब देख लीजिए प्रेजेंट करेक्ट एड्रेस दिए गए.
Lord, stay आदि तक.
हाँ, एक पोस्ट दिस केस थ्रू स्पीड पोस्ट. यार कहाँ का है ये? पाकुड़ का है.
पाकुड़.
थ्रू ऑर्डिनरी प्रोसेस एंड स्पीड पोस्ट. Office to track speed post delivery post on 23rd of February. The interim order is extended till 21st September.
दिन भर से उधर मामूली काम थोड़ी है।
Specific performance बहुत technical है। आपका कोई मैटर है?
नहीं मैटर गलत टाइम पे कर रहे हैं। 9 तारीख को एक्सपायर कर जाएगा, एंट्री है तो आइए फाइल करते एक्सटेंशन के लिए, बस कल तो नहीं हो पाएगा।
प्लीज कर दीजिए इसको डाल दीजिए। कल क्यों नहीं हो पाएगा? हम छुट्टी
कल
पर हैं।
नहीं, कल सेकेंड हाफ में
फर्स्ट हाफ कोड बंद
नहीं,
आपको अर्जेंसी है किसी करने का। हम सोचे कहीं हम छुट्टी पर
नहीं हम सोचे कि